Welcome back. Okay, we're now jumping into a new segment, and we have, of course, Heidi Thompson, who wrote an amazing book on estate planning in the state of Arizona. So please pick this up and reach out to Heidi with any personal questions that you might have as you learn things. And one of the things we were talking about previously, Heidi, was, the trust. And I wanted to just maybe go back and kind of simplify a couple things just so that people know who the players are in the trust, because a trust is, the document that you've written for yourself, by yourself. And, when it gets, addressed, you're dead, right? So you can't come back from the grave and command things. So you're doing it in writing to a document that outlives you, essentially. So tell us a little bit about, like, who are we putting in the trust, and what are their duties?
Great, absolutely. So the first person in a trust is the grantor. I know you hear that word. You might also hear the word trustor or trust maker. They're three words for the very same thing. I
Okay.
use grantor in my documents. And I want you to think about that as the person that's granting the stuff into the trust. That
Okay.
kind of makes sense. The grantor would grant the stuff into the trust. It's the one that creates it. The second person in the trust is the person receiving the things in the trust. That's the trustee. And there isn't really another word for them. They're always going to be
They're
a
always a
trustee.
trustee. Okay.
If that's you during your lifetime, you might be called the initial trustee. And when you're gone, the person coming in after you will be the successor trustee. Makes sense? They're coming next in the line. So those are really the main roles. The next person in a trust is the beneficiary. The beneficiary is the one who gets to receive everything. During your life, you're still the beneficiary. You're the one benefiting from the trust. After you're gone, the beneficiary is the people that you listed or the causes that you care about that are going to receive the things from the trust. So those are really the big roles in the trust. Some trusts also will employ what's called a trust protector. It's not that common. You might see it. Um, it Attorneys vary. I can tell you I've spent more CLE time in conversations about trust protectors than I than probably any other single topic other than the Secure Act. We probably hit on that even more.
Okay.
And we'll talk about that when we talk taxes. But the I have stopped using trust protectors most of the time.
Okay.
And uh, a trust protector is a person that you appoint that is not the trustee, that basically, if things for the trustee look like they're going to go awry and the trust isn't going to do what it should have done, they can kind of rewrite provisions of the trust so that it accomplishes the original intent. The problem with a trust protector is exactly the reason you would want one is exactly the problem with it. They can rewrite your intent.
Right.
And I've just found when I talk to most clients about the concept of that, they're like, so wait. So these provisions I did for my 20 something kid, if if the trust protector could be convinced, they could maybe give things outright to the kids. And I really can't answer that no. The
Makes
trust
sense.
protector is supposed to be meeting your intent, but they potentially could change it. So it's a long topic that lawyers differ greatly over. Having a trust protector isn't bad. It's a choice that you should make as to whether or not you would want someone to have that authority or not.
Okay, interesting. So when we talk about a trustee, so uh, upon uh, the grantor's death, the trustee, the successor trustee, then kicks in, right? And so the person that
Correct.
you've appointed, that's basically, should we
In
just
charge.
say, like, in charge of the estate?
Yes, and there's things you're looking for in that person. So this is probably the single most important role you're going to pick is the person who's going to manage all of this. And the trustee, really, the name implies, should be someone you trust. And just right there, it's in the
Fair. That
title.
seems fair.
Um,
Okay.
Fairly straightforward on that one. Should really be good with money. I like to say can rub two nickels together and make a $10 bill. So
Okay.
good with investments. Really can be unbiased between your beneficiaries um, and
Gotcha.
um, and should be able to follow your intent that you wrote down to both the letter and the spirit for anything that's a question. If they have to make any discretionary judgments, that it's someone who would make the same kinds of discretionary judgments you might make. And it's just and someone who's got good follow through. Because if it's someone who means well and thinks the same way you do, but isn't going to write the checks and do the things they're supposed to, that would not be a very good choice.
And
Um,
and and so when we think about those topics, I mean, do you give some guidance as far as like uh the age of the grantor compared to the age of the successor trustee? Are you looking for somebody generally who's you know going to be younger than you so that presumably if you passed away in old age that they're still capable of being the successor trustee?
I do a series of
Okay.
backup trustees.
So
So
you can pick multiple, you have layer.
their first successor trustee might still be the 70-year-old mom.
Okay.
She may really still be the one that's best with money, the most fair to the grandkids, the most all those things. But if she becomes incapacitated or can no longer act, then we have someone listed that's the same age as the grantors, maybe a best friend, a sibling, then maybe a niece or nephew, and then at the end, maybe a trust company if we're worried about it continuing on for generations. Or
Okay.
sometimes there's just nobody in your family that meets all of those criteria, and so you just choose a trust company. The trust company is going to take 1 to 2% per year that they're managing a trust, but they're going to follow all of the directions exactly the way they're written. They are unbiased between the beneficiaries.
Right.
They're going to do things right. And so I very often have clients just choose to go that route as well. And I am not a professional trustee. I provide a list and questions to ask them to my clients.
And so let's say you don't pick a trust company and you're just picking, close friends, relatives, things of that nature. We've just added things to their mental and physical plate, let's say, as
Yes.
soon as they become a successor trustee, do they get rewarded for that?
So most plans do allow for their reasonable compensation. And if you were to Google reasonable compensation for trustees, you're going to find it's going to say somewhere professionals are charging 1% of the trust. So if you're not a professional, you probably shouldn't be charging that much.
Okay.
I tell people if you're going to track your hours, pay yourself somewhere between 30 and $60 an hour right now. With the way inflation's going, that might go up,
Right.
but in general, that's kind of what I tell people to plan for if they're paying themselves as a trustee. Some people actually will build in a stipend into the trust. I'm not a super fan of that because we don't know what the dollar is going to do at any given
Right.
time. And if your trust isn't going to get looked at for 20 years, the $2,000 you left your trustee might not mean very much.
That's correct. Yeah, no, that's a great point. And as far as the beneficiaries, how does that work? So, I mean, assuming that they're, alive, they receive stuff, right?
Mhm.
And what happens if they're not? Are there successor beneficiaries?
Absolutely. I
Okay.
I have layers upon layers upon layers. So
Okay.
usually the way it's going to read is to their descendants, and if they don't have descendants, then to these people, and if those people are deceased, then to the remote contingent beneficiaries. And the remote contingent is what I call the Titanic provision. If all of your descendants are gone, then what charities or what favorite people do you have in the world that you'd want your estate to go to?
Gotcha. Cool. So all of those things have been thought out because when we talk about a document that outlives you by, forever,
Generations, yes.
you know, we, you'd want to build in that kind of redundancy, I would think, to that system, right?
Yes. Yes.
Excellent.
And that's what a lawyer will think through that you might not have thought through when you were sitting on legal Zoom. Right? They're thinking
Right.
about, I want my kids to get everything. Great. Until your kid passes. And then what?
Correct. And
Yes.
then what? And then what? Yeah, that series of questioning, I think, in and of itself can, uh, you know, come to its natural conclusion if you haven't thought about it and you go, oh boy, that's a hole. I just left a huge hole, right?
Absolutely.
In my estate. So that's awesome. Okay, so that wraps up this session and stand by. We will be right back with our next segment.